All right, wonderful. Good morning, everyone. The appellate court for the state of Connecticut is now open and in session. For the record, we are conducting this virtually via the Teams platform. I want to thank everyone for their patience this morning. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally, counsel for the appellee. I am Judge Cradle.
I'm Judge Suarez.
Judge Baer.
My name is Scott Fenstermaker. I'm the plaintiff appellant pro se in this case.
And Lawrence Riley representing Martha Simic. Good morning.
All right, good morning and thank you everyone. For the record, I note that I can see and hear everyone. Please let us know if in the course of your argument you are experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link that you were sent for this hearing. We will take a pause in the proceedings while that happens. All participants must keep their video on and remain in view out of respect for the process and the participants. All participants are also asked to please keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whomever is speaking, but will interrupt you if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me how much rebuttal time, if any, you would like before you begin your argument. I will be keeping track of time. I will give you a 2-minute warning when your time is almost up. It will look like this. I don't know if you can see that well, but it's a sign with the red writing. So now we are ready to hear the case of Fenstermaker versus Fenstermaker. It's docket number AC 44577. All right, and the appellant may proceed.
Good morning, Your Honor. With respect to the court, I'd like to reserve 5 minutes for rebuttal with the court's permission.
Certainly, and whenever you're ready, you may begin.
Thank you. As an initial matter, I'd like to apologize to the court and to counsel. This matter was initially scheduled for February 1st, and I did not appear. I was not aware that the case was scheduled for that day. The reason I wasn't aware is my own fault, but I did not purposely miss the attendance. And I'd also like to thank the court for exercising its discretion and permitting me to argue today. Before I begin, I would like to ask the court whether there are any areas that the court would like me to focus the thrust of my argument. Not hearing any or seeing any direction in that regard, I'd like to first address the issue of whether or not the probate court's decree in docket number 18-0399 was itself conclusive and binding. I argue that it was not conclusive and binding because this court has stated in both Buckingham and Cadle, in order to be conclusive and binding, a probate court must act under the facts and circumstances under which the legislature has conditioned its exercise of its power. It also must do so in the precise manner and in the manner particularly prescribed by the legislature. In instituting a 273, when I refer to 273, I'm referring to section 273 of Title 45A. Any sections that I refer to will be in Title 45A unless otherwise stated. In instituting a section 273 action, the probate court must wait 30 days from when it sends the affidavit in lieu of probate and administration to the Department of Administrative Services. In this case, there's no evidence whatsoever that the probate court ever sent the affidavit in lieu of probate or administration to the Department of Administrative Services. I think that there is some circumstantial evidence that the Department of Administrative Services received that affidavit as it was stamped, having received it on August 21st. However, as the affidavit in lieu of probate administration was not filed with the probate court until August 8th of 2018, and the probate court did not render its decision until August 27th of 2018, it could not have possibly waited 30 days from when it sent the affidavit to the department because it didn't receive the affidavit until 19 days before it exercises discretion. The reason that this is significant is because if, in fact, the requirement in 273 subsection C that the probate court wait 30 days before rendering its decree is jurisdictional, then by failing to do that, by failing to wait those 30 days, it did not exercise its discretion in the manner particularly described and under the facts and circumstances under which the legislature enabled the probate court to go forward under Section 273. Both Delahanty, Buckingham, and Cadle all require and mention that the probate courts are courts of limited jurisdiction. If they don't act under the circumstances and facts as particularly prescribed in the legislative enactment which grants their authority, then they do so without jurisdiction. If they do so without jurisdiction, then the decree that they've rendered under those conditions is not conclusive and binding. If it's not conclusive and binding, then the reasoning in all three of those cases, Delahanty, Buckingham, and Cadle, basically doesn't apply because, as Delahanty stated multiple times in pages 416, 419, 420, and 421 of that decision, the court must, the case was predicated on the prior decree being conclusive and binding. In this case, the decision in 18-0399 was not conclusive and binding, and therefore the reasoning behind those three cases is not in effect. Now, what I'd like to do is turn my attention to Section 128 of the Title 45A. If the court finds that my argument is unpersuasive with respect to the conclusive and binding nature of 0399, then I would argue that my application to probate the 1997 will of the decedent was in fact an application which qualified under Section 128. And what I'd like to do with the court's permission at this stage is directly cite from Section 128A, specifically the second paragraph. The second, not the second paragraph, the second sentence of paragraph A. That second sentence reads as follows: reconsideration may be made on the court's own motion or for cause shown satisfactory to the court on the written application of any interested person. And the reason that I cite to this sentence is twofold. First of all, that legislative sentence distinguishes a motion from an application. It doesn't define what the difference is between a motion and an application, but as we all know from our understanding of the rules of statutory construction, all phrases, all clauses, and all words in a statute should be deemed to have some legal effect. My argument is that an application is at some level broader than a motion. We all know that a motion is a motion, and we would file a motion, you support it with the documentation. An application, my argument would be, is any application to the court which requires, in order to consider resolving that application, requires the reconsideration of the prior decree. And another reason that I cite that sentence, and the second of my twofold reasons, is that the last clause in that sentence is on the written application of any interested person. The sentence doesn't say what type of application it has to be. It doesn't say how specific the application has to be. And it also doesn't say that the application has to specifically cite Section 128 or even ask for reconsideration. Now, the reason that's important in this particular case is that I'd like to direct the court's attention to the probate application that I filed, and specifically the cover letter. The cover letter that was filed for this application can be found at pages 544 and 545 of the appendix. As the court well knows from its reading of the papers and of the reading of the Superior Court's decision, the court relied heavily on my the wording in the first paragraph of my letter, which can be found on page 544. I wrote that I am writing to initiate a probate proceeding regarding the estate of Lloyd J. Fenstermaker, date of death June 11th, 2018. The reason that I wrote that sentence, and I will draw the court's attention to the probate decree in 0399, specifically page 211 of the appendix, is that in the middle of the first page of the decree, it says that a probate proceeding was never instituted in this action. All right. I used the word initiate rather than institute, but my intention in drafting this letter and sending it to the court was to address that specific clause in the first page of the decree in 0399, again, which is at page 211 in the appendix. All right. The court found that I was essentially trying to initiate a new action and essentially claimed that I never mentioned the initial decree. But the letter doesn't indicate that. In the next sentence in my letter, I said, I previously filed a motion with this court on or about February 7th, seeking a copy of Mr. Fenstermaker's Connecticut estate tax return. Now, that estate tax return was filed in 0399, and the court, in ruling on that motion, specifically addressed that under 0399. There was never any need to open a new action in this case. But even if the court doesn't find that persuasive, I would finally, in conclusion of my argument with respect to section 128, like to address the last sentence and the last paragraph of my letter to the court, in which I initiated this probate proceeding. The last paragraph can be found on pages 544 and 545 of the appendix. That paragraph reads as follows. I do not have the original of Mr. Fenstermaker's original last will and testament. My sister, Martha Zimick, held Mr. Fenstermaker incommunicado for the last several years of his life and has possession of all of Mr. Fenstermaker's effects, including the original January 22nd, 1997 last will and testament. Ms. Zimick is responsible for the unlawful transfer of approximately $1.5 million in assets held by Mr. Fenstermaker shortly before his passing. After Mr. Fenstermaker's passing, Ms. Zimick filed papers with this court indicating that Mr. Fenstermaker owned approximately $200 in assets at the time of his passing. And I will now say parenthetically that sentence clearly is referencing Ms. Zimick's affidavit in lieu of administration and probate in docket number 0399. I then went on to say, if this is correct, then Ms. Zimick engaged in an elaborate scheme to deplete Mr. Fenstermaker's assets and to avoid disclosing those pilfered assets during a probate proceeding. I ask that this court grant my application for letters testamentary and permit me to investigate Ms. Zimick's scheme and to effectuate Mr. Fenstermaker's testamentary intentions as stated in his last lawfully executed will and testament. Now, I understand that that letter could have been written with some additional legal precision, but the last paragraph that I just read from clearly indicates that I was seeking to have the court reconsider Ms. Zimick's filing and the decree in docket number 18-0399. And I would argue that contrary to the Superior Court's determination in its memorandum of decision, I clearly did indicate that I was seeking to have that prior decree reconsidered and in fact revoked, which the court essentially acknowledged I would have had to have done. The court, in its decision, repeatedly acknowledged that my probate filing was an application. It repeatedly acknowledged that it was a direct attack, and certainly a Section 128 application where you're seeking to revoke a prior decree is a direct attack. The court also acknowledged that I was seeking to undo that prior decree, that I was seeking to overturn that prior decree, that the sole result of my application would have been to overturn that prior decree, and that it would have wiped it out of existence. And then finally, it concluded by saying that it was abundantly clear that my application was a direct attack on, thank you, Your Honor, it was a direct attack on 0399. It's very difficult for me to understand how my application of filing the probate application could be seeking to undo, overturn, wipe out of existence, and directly attack the probate decree in 0399 without also at the same time seeking to revoke it. If the court were to hold in that regard, it would be to seem to be essentially playing semantic games with the idea of revocation. And finally, Mr. Riley, in his own papers, on page 11 of his response brief, specifically in the fourth line of his response brief, acknowledged that the effect of what I was trying to do was to revoke the decree in 0399. So, in summary, with respect to the 128 issue, Your Honor, Your Honors, I would argue that Section 128 does not specifically require the applicant to ask for reconsideration or for revocation or revisement. And also, the effect of what I asked to do was I did ask that the court reconsider that decree and to revoke it. Unless there are questions from the court, I will reserve the rest of my time for the rebuttal.
Okay, and you've finished just about at 15 minutes, so you'll have your 5 minutes remaining for rebuttal.
Thank you very much, Your Honor.
You're very welcome. Attorney Riley.
All right, I have my microphone on. Am I in good shape? Okay, thank you. May it please the court. My name is Lawrence Riley, and I represent Martha Simic on this appeal. The plaintiff appellant's appeal brings to the court a very long baggage train filled with stories of intrigue and accusations, salacious stories about vanishing assets, cursing and foul language, and really years and years of fighting between the plaintiff and his father and between the plaintiff and his siblings. And I think all of that noise threatens to distract the court or the reader of the appeal from the seminal issue in this case, which is, does the probate court, being a court of limited jurisdiction, does the probate court have the authority, after having entered a final decree on the estate of a decedent, does it have the authority 1 year later to accept what is purported to be a different will from the same decedent, the result of which would be an irreconcilable crash or conflict with the prior decree of the court? And the answer to that question, according to 100 years of Connecticut jurisprudence, is no. That is as simple as this appeal can get. The Superior Court had before it only the issue that was presented to the probate court, and the Superior Court on appeal had only the authority granted to it by the probate, only had the authority of the probate court in hearing an appeal from probate. So the Superior Court was in no better position to exercise subject matter jurisdiction over this case than was the probate court. According to the Buckingham and Delahanty decisions, which were much more sympathetic than the plaintiff in this case, the probate court and the Superior Court on appeal simply do not have subject matter jurisdiction to accept for filing another will on an estate that has already been closed. That is the issue on this appeal. And as far as my client is concerned, that is the end of the proper legal analysis on the appeal. That is all that's been brought before the court, and Buckingham and Delahanty definitively answer the question in the negative for this plaintiff. I think it's important when considering the rest of the arguments on the appeal to keep focused on three things, Your Honors. The first is that this is not an appeal from 18-0399. Scott Fenstermaker did not file an appearance in that case. He did not file an appeal from that decree. He knew about his father's death within 1 month of his passing. He knew about all of these subsequent wills that his father signed after the 1997 will. And we know that because Mr. Fenstermaker had instigated the federal proceeding that we discuss in our brief, and all of the subsequent wills had been produced to him in that action. So he knew about the 97 will, he knew about the 2 wills drafted by Attorney Plankinton, he knew about the wills drafted by Attorney O'Brien, he knew that he was disinherited in all of those wills, and he had seen affidavits from the attorneys and from his father discussing why he had been disinherited. And he had all this in his hand a year before his father passed away in June of 2018. He learned about his father's death within a month. He alleges that in his moving papers. Under Connecticut statute, he was obligated by law to file with the court a will if he knew that he had a will of that decedent. And just like in the Delahanty case, remember that in Delahanty, the court assumed that the will that was being offered by the movant in that case, the original of that will had been destroyed fraudulently by the executors of the other will that had already been admitted to court. So it's no excuse to say that Mr. Fenstermaker only had a copy. He was obligated by law to present to the probate court whatever he had. Had he done so, he would have presented to the probate court in July of 2018 what he claimed to be the last will and testament of his father, and that would have alerted the probate court to this problem or to the issue. And on this point, I would refer back to Mr. Fenstermaker's argument that he was in his 19- I'm getting the docket numbers mixed up now. 19-0444, I think it is, was the matter that's on appeal now. Mr. Fenstermaker is now claiming that the particular verbiage that he used in his cover letter to the clerk was addressing a line in the prior decree that said that no prior probate proceedings had been instituted in connection with the estate of Lloyd Fenstermaker. And I would correct that. What the probate court was doing in including that sentence in its final decree in 18-0399 was quoting from the Connecticut small estate procedure statute, 45A 273 subpart D, like David. That subsection says, skipping the prefatory language, if the court finds that no probate proceedings have been instituted in connection with the estate of the decedent, then the court shall determine, et cetera, et cetera, et cetera. That was a necessary finding by statute for the probate judge to make. And he specifically said that no one has filed any will of Lloyd Fenstermaker that would disturb the proceedings under our small estate procedures. Had Scott Fenstermaker filed his father's will, it would have brought him before the probate court, and the probate court would have ruled on the issues that Scott Fenstermaker is now attempting to bring to the court on appeal. But he can't do that. The Connecticut state procedures allowed him the opportunity to file the will, and indeed obligated him to file the will, that would have brought before the probate court 2 different instruments, and it would have teed the issue up for the probate court to deal with this issue. Scott Fenstermaker chose not to do that. In November of that year, he went to the probate court, he visited the probate court and looked at the file. We know that because he alleges that in his complaint. That is at page A10 of the appendix. So in November, he knew about the contents of 18-0399. And he would have seen, if he looked at the file, that a final judgment entered in the case administering the estate under the small estate procedures without letters of administration. So he had every opportunity to participate. He could have filed a motion for reconsideration at that time because the Connecticut legislature also provided for a 1-year appeal period from an ex parte decree. So he would have been within that 1-year appeal period. Had he filed the will, it would have brought him before the court. Had he filed a motion for reconsideration, it would have brought him before that court. Had he filed an appeal, it would have raised these issues before at least that court or the Superior Court. Any one of these steps would have brought Scott Fenstermaker into the probate court to have adjudicated the issues that he's now trying to raise on appeal. Having not gone through any of those procedures, he cannot do it now. So says Delahanty and Buckingham. The second issue that I would point out, the first is that 18-0399 is not on appeal. The second issue is that Scott Fenstermaker has never, and we're now February 23rd, 2022, he has never filed an application for reconsideration, ever. The first time he ever mentioned reconsideration or an application for reconsideration or a motion for reconsideration or a request for reconsideration, whatever he wants to call it, the first time that was ever raised was in the briefing opposing my motion for summary judgment in the Superior Court, and it was never raised in the probate court. So I think that his arguments about the difference between a motion and an application is a distinction, a difference without a distinction. It makes no difference whatsoever whether one calls it an application or a motion. It has no bearing on this issue. He simply never did it. He filed the 1997 will under a letter that said he is writing to initiate a probate proceeding. That's all. So there is no issue really before this court on the parameters for a motion or an application for reconsideration because none has ever been filed. The last point I would raise, or the last thing I think it's important for us to remember is the questions that Mr. Fenstermaker raises about the constitutionality of Connecticut's small estate procedures under 45A 273 is not on appeal here because the matter on appeal, which is 19-0444, was not a small estate proceeding. It was an application to probate a will when there was already a prior judgment a year old accepting the administration on that estate. There is no question properly raised in this case as to the constitutionality of 273. It simply does not exist. The last issue that I would raise to the court, really just to rebut one or two things that Mr. Fenstermaker argued during his time, was his claim that the final decree in 18-0399 is not conclusory or binding. And I find that to be very strange. We briefed the legislative history of that act. It seems obvious that the 30-day requirement of notice to the Department of Administrative Services is there for, number one, the protection of any interest that DAS may have in the estate to recoup monies paid to the decedent, or number two, to limit the time in which DAS may assert any such claimed lien or payback obligation. If they don't get back to the court within 30 days, then they've lost their rights. We know from the appellate record in the case, and this is at appendix page 555, we know that the appellate court, we know that the probate court sent a copy of the affidavit in lieu of probate to DAS. DAS stamped receipt of that on August 21st, and on August 22nd, stamped it again. DAS waives, and signed it and dated August 22, sent it back to the probate court, which stamped it again, received on August 27. So when Mr. Fenstermaker says there's no evidence, yes, there is. Appendix page 550 shows the probate court sending that document to DAS and receiving from DAS a notification that there was no lien claimed. Once DAS indicated that no lien was being claimed, there is no reason to delay anymore. And so the probate court issued its final decree in the case. I think that is all I wanted to emphasize in the case. The final thing that I would say in closing, Your Honors, is that, and this court has found this on a number of occasions, final judgments are presumptively valid, and collateral attacks on the validity are disfavored. The reason is simple, that the court and the legislature and our government and our society vests an enormous amount of weight in the finality of judgments. The legislature has provided, with respect to probate proceedings for the administration of wills and probate proceedings for small estates, procedures for litigants, if they wish to go to the probate court and be heard. They have the ability to ask for reconsideration. They have the ability to participate and file documents and objections. They have an appeal period. In particular, with respect to ex parte proceedings, they have a 1-year appeal period. All of these procedures are in place to allow persons like Scott Fenstermaker to go at the proper time and be heard with respect to complaints that they have. To suggest that the Connecticut legislature created 45A 273 and also created a separate statutory regime saying that because no notice was provided to other parties, 273 judgments are not conclusive or final or binding is absurd. It would mean that the legislature intended for non-binding, non-conclusive judgments and decrees to be entered by the probate court. It would lead to the conclusion that the legislature created an appeal right from ex parte proceedings which are not final or binding on any parties. Both of those conclusions are absurd, and we're supposed to avoid absurd conclusions in the law. If a litigant neglects to participate by motion, by appearing, by appealing at the proper time, by taking the steps that the legislature has created for this very purpose, then that litigant cannot be heard in a subsequent case to complain about a prior judgment entered by the court and try to disturb that judgment. That is exactly what is not allowed by the Buckingham and Delahanty decisions, and that is exactly the wall against this plaintiff founders in the case. So unless the court has any questions for me, I will yield the rest of my time back to the court.
All right, seeing none, Mr. Fenstermaker, you have 5 minutes for rebuttal.
Yes, Your Honor, thank you very much. I just want to point out one thing in Larry's discussion. Larry mentioned a page in the appendix 555 regarding the stamp that the Department of Administrative Services put on it. The page is actually 550. So to the extent that the court finds that material, the court should look at page 550, not 555. As an initial matter, Your Honor, during Larry's excellent discussion, he mentioned repeatedly 399 being a final decision. Again, Your Honor, 399 was not, or the court, 399 was not a final decision. 399 was issued approximately 11 or 12 days before the court had jurisdiction to render that decision. I understand Larry's argument regarding what he believes the intent of the legislator to be in this case, But if the legislature truly wanted the court to render a decision after either 30 days or after it received notice that the department didn't have any claims, it could have easily drafted the statute in that manner. The statute was drafted the way that it was for a reason. And the probate court failed to follow the statutory mandate. And in doing so, it did not have subject matter jurisdiction. The first time that the probate court issued a final decree in Lloyd Fenstermaker's estate was in October of 2019. That decree was, in fact, rendered more than 30 days after the Department of Administrative Services received the affidavit in lieu of probate administration. Larry incorrectly says that there's proof that the probate court sent that affidavit to the Department of Administrative Services, but there's no such proof. The only proof is that they received it. Now, because the probate court's
Mr. Fenstermaker, I assume when you say Larry, you're referring to Attorney Riley, is that correct?
I apologize, Your Honor.
Thank you.
I apologize, Mr. Riley, yes. And Your Honor, because the probate court's decision in 399 was not final when it rendered it on August 27th of 2018, Buckingham and Delahanty do not apply. In addition, even if the court finds that my argument in that respect is unpersuasive, Buckingham and Delahanty both hold that a probate decree can be attacked if there's statutory authority to do that. And there is statutory authority in this case, and that statutory authority is Section 128. In Delahanty, 128 hadn't been enacted at that stage, but there was a similar statute. But in that case, the reconsideration application had to be applied for before the settlement of the estate. That didn't happen. In Buckingham, there was two reasons why 128 didn't apply. First of all, the litigant did in fact have notice of the prior proceeding, which he sought to challenge, and therefore it wasn't ex parte. But even if he had notice, or even if he didn't receive notice, as the term ex parte is defined in 128, that was not an ex parte decree. The last sentence of Section 128A reads as follows: for the purposes of this section, an ex parte order or decree is an order or decree entered in a proceeding of which no notice is required to be given to any party and no notice is given. In Buckingham, the proceeding that the applicant sought to challenge, there was notice required. So Section 128 simply didn't apply to Buckingham in any way. There's no question in this case that the 273 proceeding that Martha Zimick relied upon to administer Lloyd Fenstermaker's estate was in fact ex parte. 273 clearly grants the ability to have an ex parte proceeding, and in this case, 399, there was no notice given. Therefore, 128 applies. The only question in this case is whether or not my application to probate that prior will was in fact a 128 proceeding, and for the reasons that I stated on my initial argument, it was in fact a 128 proceeding. If the court has any questions, I'd be glad to answer that. If not, then I would rest my argument. Your Honor, is the court muted?
The court is. Thank you very much. Thank you both for participating in this virtual hearing. We look forward to seeing you in the courtroom in the future. We will, in fact, take this matter under advisement, and we will adjourn until Monday, February 28th at 10 a.m. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.